We are live.
Welcome to the House Judiciary Committee this Wednesday morning, May 21st. And in preparation for next year's session, we're looking at getting some initial walkthroughs on a few bills, and H-183 is one of them that we want to take a look at and see if we're going to be lining it up for early next year. So over to you, Eric. Thank you for being here.
Yes, you bet. Thank you. Nice to see everybody this morning. Eric Fitzpatrick with the Office of Legislative Counsel. As the chair said, here to do a walkthrough of H-183, which is an act relating to strict liability for damages caused by domestic dogs. This is actually a reintroduction of a bill that was introduced several years ago, 2021. It was H-250 at that time. So it's been around for a few years, originally drafted by Bryn. So I like the full circle nature of that, since now she's Director and Chief Counsel. Back when she was on the Judiciary team staff. So there's two things that really are going on in this bill. And as you can tell from the title and what I just said, it has to do with damages caused when somebody is, either there's a domestic dog bite or some other injury to person or property that's caused by a domestic dog. And under current law, and this is the language that struck out from pages 1, 2, 3, what that language does is it sets up a process that a municipality has to follow if a person files a complaint with the municipality about there being a dog bite, for example, some sort of injury that was caused by a domestic dog or a wolf hybrid. And there's this process that's laid out there that the municipality has to file. So, if this complaint gets filed, then they have to investigate within a certain amount of time. They have to provide an answer within a certain amount of time. The procedures are fairly detailed. However, there is an exemption over on the top of page 3. Again, this is all struck, but this is the current procedure. So that these processes only apply if a municipality hasn't adopted something on their own. So it doesn't override what a municipality can do. Municipality still has the authority under subsection E, top of page 3, by a vote of the voters to regulate domestic pets or wolf hybrids by ordinances that are inconsistent with this section, in which case those ordinances shall not apply. So in other words, this is sort of a fallback that applies if the municipality hasn't done something different. So the town always has that option to say they want to go a different route, but if they don't, then this is the process that applies. Now think for a second, this is just how the town has to respond, right? The proposed new language here doesn't have anything to do with the town response. The new approach has to do with how a civil lawsuit between private people, civil liability. So say a victim of a dog bite, how does that lawsuit get handled by the courts? So the two things here aren't necessarily mutually exclusive. The proposal is strike the municipal language, how the municipality has to respond, but it doesn't have to be that way. You could keep that and add the new language as well. It's just the choice that was made in the drafting of it, but there's no legal impediment to having both of these options. One would be the municipal response, and the other is how would a private lawsuit be handled between the injured party and the owner of the dog. So on that topic, how would this private lawsuit be handled? And that's what the proposed new language governs. And the basic proposal is to establish a strict liability standard. You see that line 9, subsection A of page 3. So in other words, there's essentially no legal defense for the owner to make if some of these initial criteria occur. Those criteria are laid out there in subsection A. That means it establishes this statutory duty. So in other words, when you file a negligence lawsuit against somebody and you're filing a suit for damages, you have to establish that that there was a duty to exercise reasonable care against you, the injured party. In this case, the statute establishes that duty for you. Sometimes that happens in statute. That's not uncommon. Sometimes the legislature chooses as a policy to say, we're going to establish a statutory duty here. It's not up to the plaintiff, the person who files a lawsuit, to get the court to say, oh, okay, we agree there was a duty. It's already laid right out there in statute. Owner has a duty to keep the dog under reasonable control at all times. And see, there's two things here, and to keep that dog from running at large. So you have to keep the dog under reasonable control, and you have to keep the dog from running at large. If they don't do that, then they are liable for any damages that result to the injured person. So that's what it means by strict liability. You're not imposing any proof requirements on the person who files such lawsuit. The statute essentially lays it out there for you. You've got this duty to keep your dog from running around out of control, and to keep the dog from running at large, and keep the dog under reasonable control. If those things don't happen, then you're liable for any resulting injury, essentially. Regardless, this is line 12.3, regardless of whether the dog has shown any dangerous propensities or whether the owner knew or should have known of the dog's dangerous propensity. So in other words, the owner can't, in a lawsuit, but raise a defense that says, hey, I can't be liable for those damages because I didn't know that the dog had this propensity to go bite people or this propensity to go run off leash. By statute, you said that the injured person's going to be able to recover their damages for the bite, regardless of whether there may have been evidence that the owner could introduce that says, it's unreasonable to hold me liable for this because there's no way I should have been able to know that that was going to happen.
It almost seems sort of like, is it almost redundant? Or, I mean, if I have a dog and it does something bad and somebody gets bitten,
Right?
not liable.
You could be, but I think under the common law, you would have the opportunity as the dog owner because you have to exercise reasonable. That's your sort of general standard for a negligence personal injury lawsuit. But if, let's say, the dog had never done anything like that, the dog had never bitten anybody, there was no evidence, then you might be able to show as an owner, well, it wasn't, in this case, it was reasonable of me to think that that wasn't going to happen. So you might not be held liable. This is saying, doesn't matter whether there was any reason to think the dog was ever going to bite anybody or not, you're still going to be responsible for the damages.
Was this as a result of a domestic dog or a wolf hybrid? Was it a wolf hybrid that sort of facilitated this to happen? Or I don't know. I'm just trying to figure it out.
I don't know either. I did ask, because originally this bill, as I said, came from 2021, and I did ask Brent, hey, do you remember anything about that? And she said she did sort of remember a dog bite situation, but she wasn't aware of the particulars.
The last biennium, I'm trying to remember who was the sponsor of the bill, or maybe it was the biennium before. It had some stories of individuals who had
Swan.
Yeah,
Carl,
yeah.
Yes.
That's what it was.
And him and Rep. Zembrowicki were the two they co-sponsored. Carl.
You have a question, Ken?
Rehnquist or something?
Yes.
Right.
There you go.
Nice. So I just is it really strict liability? It seems like it's just negligence at a different place, that the reasonable control. I mean, if that.
Yeah, I agree with that. I noticed the same thing. It's like, well, uses that term, and it's not technically true because you do have this. If it were true strict liability, it would be a dog bites somebody, you pay. That's it. No, there's no.
It's reason under.
Exactly. So, in a way, there is sort of it could almost has components of both because you're still removing some defenses, I think, from the ability of the dog owner. For example, they can't argue foreseeability, that sort of thing.
Anything else?
Right.
Can it be called sorta strict liability? Should we change it?
Yeah, I'm fine with that. I think that works. Strict-ish liability.
Even better, yeah. Right.
That's why insurance is so expensive. Homeowners insurance is so expensive for a dog.
Yeah.
Interesting question. We have an insurance attorney who could look into that a little bit.
So over to you. I don't think you would. Did you go through all of it yet?
No, that was just the strict liability part, because there are some exceptions. Exceptions to the strictish liability. It begins over down the bottom of page 3 over onto the top page 5. So this means, in other words, this liability standard that we've just described would not apply in some of these listed situations. First one is if it's a government agency using a dog in military or police work. If the injury occurred during the course of the dog's official duties, that's one. Over on to page 4 now. If the owner of the dog, if the injured person was trespassing upon the dog owner's property, then you don't get the benefit of this. Subdivision B, injury occurred while the dog was protecting the dog's owner or another innocent party from attack. by the injured person or a dog owned by the injured person. So in a sense, it's a self-defense sort of situation there, right? Or defense of others, I should say. Both apply there. Subdivision C, injury occurred while the dog was securely confined in a kennel, crate, or other enclosure. And lastly, subdivision D, injury occurred as a result of an injured person enticing, disturbing, alarming, harassing, or otherwise provoking the dog. So some sort of provocation by the person who got injured. Then you're not going to be able to get this automatic, semi-automatic recovery for damages if you were the one who started, essentially. Lastly, you have some definitions. Domestic pet, I looked at that cross-reference definition. It just defines domestic pet to include a domestic dog. Doesn't actually define domestic dog, but I think that's sort of common usage of the language. And talks about some specific language about what it means to be the owner of the dog, and what running at large means, which is an important point because that's an important component of the liability. Means a dog goes uncontrolled by the dog's owner upon the premises of another person without the consent of the owner of the premises or of another person authorized to give consent, or goes uncontrolled by the owner upon a highway, public road, street, or any other place open to the public jet.
So running at large related to keeping the dog under reasonable control.
I think the way I read that, and that's back in subsection 8.
Yeah.
Yeah, the way I read that is that the owner has two separate duties there. Keep the dog under reasonable control and keep the dog from running at large. So I think that if the dog is running at large, then they've breached their duty. It's almost like a specific way that you are not exercising reasonable control.
So it's not exercising reasonable control if the dog is running at large, but there may be other situations where the dog's not running at large, but there's not reasonable control.
Exactly.
Yeah, Bart.
So I know a lot of towns, and I think it's towns that have leash laws.
Right.
Not the state, right? The state doesn't have it.
Right.
So if a town has a leash law, running at large is already violating the leash law. But if a town doesn't have a leash law, then this would be relevant for that particular.
Actually, that's a separate issue, the town leash law, in the sense that whatever, like I think the way the leash law works is that a person violates it, then there's some kind of municipal violation. You can get ticketed for a municipal violation. That's a separate thing. This has to do with a civil lawsuit between parties for money damages. Now, the fact that the person had obeyed the town's leash law would be very relevant in this.
Right. If they, right.
Right.
Okay.
Or if they hadn't, for that matter, would both be relevant, but it wouldn't necessarily preclude or decide how the person's private damages lawsuit ended up.
And there are also dog parks, right? Which the purpose of which, right, is for dogs to be able to run free. And they're not excluded from this as well, because I guess you need to keep control over your dog, even at a dog park. If your dog is running, they can't go and just start.
An interesting question. You're right that they're certainly not specifically addressed in this bill. So how that would play out is an interesting question. I would say someone gets injured at a dog park where it's probably permissibly, I'm not a dog owner and I don't know the rules at dog parks. I know that we don't bring our cat there. So that's reasonable, I think.
I have no idea where that came from.
I was just trying to, that's as much as I know about dog parks. And the
That's
That's an interesting point.
right. So, but maybe I don't know if the rules of the dog park are, it's okay to let your dog run loose, then one would think that there would not be a violation of the running at large provision if you're within a space where running at large is permitted. One would
probably have to address that in here, I would imagine.
Right.
Ian and then Karen. Are you going?
Okay.
Ian and Karen.
Just two quick questions. One, is the injuries only to people?
I believe the answer to that is no, because I thought I remembered that perhaps it was one of the case I was reading.
Mr. Platts?
Although,
Yeah, I think,
although,
a dog injuring another dog, I feel like it's a fairly common.
yeah, exactly.
Yeah,
Exactly.
so would they have strict liability on that type of injury?
Although I'm looking at line 15 now.
Yep.
Person who breaches the duty imposed by this section shall be subject to civil liability for any damages suffered by a person who is injured by the dog, whose domestic pet, et cetera, et cetera. Although in the first sentence, it just says injured.
Yeah.
Or sorry, the second sentence, the owner may be held liable for any injury that's caused by the dog. So that is a good catch and should be clarified one way or the other.
Yeah, and I don't really know which makes more sense.
Right.
Yeah.
Right.
And then my other question was, can you move into a strict liability statute like this, a breach of a municipal ordinance?
Yeah, you mean it's something along the lines of, say, it shall be deemed a violation or some way to say that the breach of the municipal ordinance.
Triggers the,
Yes,
Yeah.
yeah, we've done that sort of thing in different statutes.
so that would be interesting to see in there too, be just like, yeah, if there was a leash law and you were violating leash law, if someone was injured, bam. strict liability.
Yep.
My question was kind of similar to Barbara's. I'm thinking about, and maybe this would be covered under the municipality part of it. I don't know, is like in Essex, there is a park in Brook where
Right.
like you're allowed to bring your dogs and have them off leash.
Yeah.
And so I'm maybe not so much concerned about the biting piece of it, but thinking like dogs could just be running around, somebody trips over a dog or something, I don't know.
Mhm.
Like, it seems like that wouldn't be covered. So like there might be some more that we would need to do in this to make sure all areas were covered. Because municipalities have done their own things in
Yeah.
allowing dogs off leash in certain areas.
Yeah, I think that that's a point that you would want to look at. For example, something along the lines of another interplay that you're kind of getting at with local municipal ordinances. On the one hand, yes, a violation could be construed as a violation of this. On the other hand, if the municipality has designated areas where dogs can run off leash, that may be something as a policy matter you may want to include as saying if the injury occurred while the dog was running off leash in an area that the municipality has designated where that's permissible, maybe that wouldn't be a violation. Again, a policy decision, but exactly the kind of things you want to be thinking about when you are.
So Ian's question led me to think about other damages that are done. My husband once got bitten by a dog, and the dog not only, actually, I think the dog mostly did damage to the clothing because it was winter. And so it like tore into a jacket.
Right.
So does it include, or I suppose also a dog could do some property damage while it's angry? This, because we're talking about injury, we are not talking about adding in any kind of property damage.
Well, again, it kind of goes to the language. I would read the language on line 15 for any damages suffered by a person who was injured. I would read that to include property damage. Certainly want to make sure it's not wouldn't be unusual and a good idea if there were something you wanted to move forward with to define what you meant by injury. So what you thought should be included. Include, and as I say, that's done in other statutes sometimes. Injury to person, injury to property doesn't include emotional damages, that sort of thing. You could be explicit about that. I think that would be helpful. I think that arguably the damages piece does include property damage, but again, better to be clear one way or the other.
Any other questions for Tom?
To back to the government one, obviously I'm thinking about law enforcement dogs. And
Right.
potential loophole. Sometimes the dogs are owned by the government or the state, city, the municipality, whatever. Sometimes they're owned by the individual. And if the dog, while at work in the performance of its duties, it does happen to have a dog bite or something that wasn't work related, the owner would still be the officer. Would they be responsible for that? Or
So-
the municipality?
Right.
The dog would work.
Yep. So in the example you were describing was the dog, because I'm looking at the exception bottom of page 3.
Oh.
It didn't occur during, maybe it was a bite that occurred not while the dog was on duty? Or
Yeah, while the dog was on duty, but it wasn't necessarily work related
Oh, I see. Well, let's see.
because these dogs sometimes are actually, fairly aggressive.
Right, right. Well, you could certainly, if that were something that you wanted to cover, you could play with that language a little bit, because you're right. I think the way it reads now, government agency using a dog in military or police work, if the injury occurred during the course of the dog's official duties. So if the issue is that sometimes because of the training of the dog, a bite occurred that was outside of the course of the.
Unrelated to its.
Yes. Yeah, you could, tweak that language so that it covered that as well. Policy decision, obviously, whether you think that's a good move or not, but you could certainly do that.
All right. Any other questions? Not seeing any. So I believe, do you know, Nate, for sure Ben is able to make it? Do you have any
Yes, you can.
confirmation?
I'll be here.
Okay, so Ben is going to be here momentarily to go, we're going to need a straw poll on H44, which we've already had Ben walk us through it, but just in case there were any questions, because that will be on the floor for second reading tomorrow. And we'll go ahead and also do H222, which is on its way. It's already gone through third reading. We just haven't gotten it. It should be on our notice calendar tomorrow. So we'll do those two straw polls. And I think that's all the business we have for today. Even though I think it's going to be relatively short. Is it going to be that short of a? Yeah, it'll be constituent services this afternoon.
Oh,
Yeah.
gotcha.
So. All right. So thank you, Eric. And I